Everyone. Thank you for joining me today. My name is Michelle Pomerantz. I am a certified financial planner and asset manager with Wiener Schultz Wealth Group in Perrysburg. I've spent 25 years in working on financial planning and asset management and elder care. Today is an essential yet an often overlooked topic, financial planning for seniors, particularly those facing dementia or needing extra care and the vital role caregivers play in this process. Financial planning is crucial at any age, but for seniors, particularly those with cognitive impairments like dementia or needing extra care, it can be a matter of maintaining dignity and quality of life. Today, we're going to explore how dementia or needing extra care impacts financial decision making and the importance of early planning and strategic strategies for caregivers to help navigate these challenges. Oh, there it goes. What? All right, we got slides going. All right, senior often encounter a variety of challenges when managing their finances, which can be exacerbated by health issues, cognitive decline, and changes in their living situations. Here are some common challenges that they face. Cognitive decline, memory loss, difficulty remembering transactions, bills, or financial commitments that can lead to missed payments and confusion. Decision making. Cognitive impairments can affect their ability to make informed financial decisions, leaving them vulnerable to scams or poor financial choices. Health issues, medical expenses, rising healthcare costs. Did you see the cost of eggs at the grocery store? Oh, that's kind of crazy. Yeah, including medication, treatments, long-term care, and strain, fixed incomes, and complicated budgeting. Physical limitations. Health problems can limit mobility, making challenges to visit banks or attending financial meetings, which can hinder effective financial management. Fixed income, limited resources. Many seniors rely on fixed income, such as Social Security or pensions, which may not keep pace with inflation or rising living costs, leading to financial stress. Budgeting constraints. With limited income, seniors may struggle to cover essential expenses while also saving for emergencies or unexpected costs. Frauds and scams, increasing vulnerability. Seniors may have more susceptible to financial scams, including fraud that target their trust and lack familiarity with technology. Isolation, social isolation can create the likelihood of falling victim to scams, as seniors may engage with strangers out of loneliness. Lack of financial literacy, understanding financial products. Many seniors may struggle to understand complex financial products, including investments and insurance and retirement accounts. Technological barriers. With the rise of online banking and financial management tools, seniors who are not tech savvy may find it difficult to navigate digital platforms. Estate planning challenges, lack of preparedness. Some seniors may not have adequate estate plans in place, leading to confusion or disputes among family members regarding asset distribution. Reluctance to discuss mortality. Who wants to talk about their death? Discussions about wills, trust, and end-of-life planning can be uncomfortable, causing many seniors to postpone or avoid these important decisions. Finally, family dynamics. Dependency on family. Some seniors may rely on family members for financial management, which can lead to feelings of loss of independence or control. Conflict over finances. Family disagreements about financial decisions or care arrangements can create additional stress for seniors. Change in life situation. Downsizing or reallocating. Moving to smaller homes or assisted living facilities can involve significant expenses and emotional challenges, complicating financial management. Adjusting to new costs, seniors may face new expenses relating to care, services, transportation, or home maintenance in different living situations. Inadequate retirement savings and significant funds. Many seniors find that they have not saved enough for retirement, leading to financial strain and difficult choices about lifestyle changes. Pension shortfalls. Changes in companies' policies or pension plans can leave some seniors without the financial support they expected. Emotional stress. Anxiety about finances. The pressure of managing finances can lead to anxiety and stress, impacting overall well-being and mental health. Loss of independence. Financial difficulties may force seniors to rely on others for support, which can lead to feelings of helplessness or loss of autonomy. Addressing these challenges requires a multifaceted approach that includes education, support, and resources tailored to the unique needs of seniors. Families, caregivers, and financial professionals can work together to help seniors navigate these obstacles, ensuring they maintain control over their finance and quality of life as they age. Did it move?
Because
Okay, the importance of early financial planning. Now, let's talk about why early financial planning is essential. Planning ahead empowers seniors by allowing them to communicate their wishes clearly. It also provides a safety net for both the seniors and their family, reducing anxiety about future needs. One of the key benefits of planning early is that can help avoid family disputes down the line. When everybody knows the senior's wishes, it minimizes the potential for misunderstanding or conflict among family members. And I would appreciate that because people will fight in my office. For instance, I worked with a family who established a comprehensive financial and care plan while their mother was still mentally sharp. They documented the preferences for medical treatment, living arrangements, and even financial priorities. This insight not only reassured their mother, but also provided clarity and peace of mind for everybody involved. Delaying these decisions can lead to missed opportunities and increased stress. It's critical to have these conversations sooner rather than later, ensuring that everyone is on the same page. Now, let's dive into a key component for financial planning for seniors. Budgeting and managing expenses. Creating a budget is essential. Start by tracking income and expenditures. It's vital to include not only everyday expenses, but also potential healthcare costs, which can be substantial. Planning for medications, therapies, routine medical appointments can avoid financial strain. Estate planning is another critical aspect. This includes creating a will, the possibility of a trust to ensure that assets are distributed according to the senior's wishes. It also is essential to designate a power of attorney for both financial and healthcare decisions, ensuring that someone's trusted can make choices that the senior cannot. Now, Jen Ramon is here today, and she's going to talk a little bit more about that subject. One family I encountered faced a daunting legal battle over their father's estate simply because he did not have a will. This situation caused significant stress and conflict among the siblings, which are still not talking today, and that was 15 years ago, emphasizing the needs for clear documentation. Long-term care insurance. Consider long-term care insurance. This type of insurance can help cover costs associated with care facilities, home health aides, and other long-term support services, easing the financial burdens on family. I often share a story about a couple who purchased a long-term care insurance in their 50s. When the wife developed early onset dementia in her 60s, they were both relieved to have that insurance, which allowed them to hire caregivers to assist in her home, maintaining her comfort and dignity. Exploring financial resources and assistance programs available for seniors. Programs like Medicaid and supplementary Social Security income can provide critical support. It's wise to familiarize yourself with local resources that can assist in times of need. For instance, local area agency on aging is often provides valuable information about available services and support for seniors. These organizations can guide families in navigating a maze of options available to them. Now let's discuss strategies that caregivers can implement to support seniors in financial planning. Communication with seniors who may be resistant to discussing their finances can be challenging, but critical for ensuring their well-being. Here are some effective strategies to facilitate these conversations. Creating a comfortable environment. Choose the right setting. Opt for a quiet, familiar place where the senior feels safe and comfortable, avoiding distractions and interruptions. Be patient. Allow them time to express their thoughts and feelings without rushing the communication. Use empathy and understanding, acknowledging their feelings, recognizing that discussions about finances can be stressful or intimidating. Validate their concerns and emotions, show compassion, approach the topic with a genuine desire to understand their perspective. This can help build trust and openness. Use clear and simple language, avoid jargon, use straightforward terms, and avoid complex financial terminology that may cause confusion or overwhelm them. Break down information, present information in small, digestible pieces. This can make the discussion feel less daunting. Ask open-ended questions, encourage dialogue. Instead of yes or no questions, ask open-ended questions like, what are your thoughts on how we manage your finances? This encourages them to share their feelings and options. Listen actively. Demonstrate that you are listening by nodding and paraphrasing what they say to show understanding. Focus on their interests and goals. Personalize the conversation. Frame discussions around their interests and goals. For example, ask them how they envision their retirement or what their priorities are for their care. Discuss benefits. Emphasize how discussing finances can help achieve their personal goals and maintain independence or plan for travel. Involve them in decision making. The collaborative approach. Encourage participation by asking for their input and options on financial decisions. This can help them feel more in control. Set goals together. Work together to establish financial goals, which can foster a sense of ownership and responsibility. Provide reassurance and support. Reassure them, let them know that discussing finances is a normal part of aging and that you are there to support them. Offer assistance. Suggest that you can help manage financial tasks or connect them with professionals who specialize in elder care. Using visual aids, charts and graphs. Consider using visual aids like charts and graphs to illustrate financial information clearly. Visuals can help simplify complex concepts. Written summaries. Provide written summaries of key point discussions, which can serve as reference for them later. Be respectful and patient. Respect their wishes. If they remain resistant, respect their boundaries while gently reminding them of the importance of financial planning. Follow up later. If the conversation doesn't go as planned, consider revisiting the topic later when they may be more receptive. Involve trusted family members or friends. Seek support. Sometimes involving other family members or friends whom seniors trust can facilitate the conversation. They may feel more comfortable discussing sensitive topics with someone they trust. Share experiences. Encourage the trusted person to share their own experience to normalize the conversation around financial planning. By employing these strategies, you can create a more productive and respectful dialogue with seniors about their finances, making it easy for them to engage in these important discussions. Oh, here's a good subject, which unfortunately is happening more and more as my years go on. Financial fraud targeting seniors. Financial fraud targeting seniors is a significant and growing concern. As individuals age, they may become more vulnerable to various forms of financial exploitation, often due to cognitive decline, social isolation, or lack of awareness about financial scams. Here is an overlook of potential for financial fraud against seniors, including common types of fraud, risk factors, and strategies to prevent victimization. Telemarketing scams. Scammers often use phone calls to promote fake products or services, such as health-related products, sweepstakes, or vacation deals. They may pressure seniors into making hasty decisions. Investment scams. Fraudsters may often seemingly create investment opportunities, often in the form of high yield bond or stock products. These scams can lead to significant financial losses. Online scams. Seniors may fall victim to phishing emails or fraudulent websites that impersonate legitimate organizations, leading to identity theft or unauthorized access to personal accounts. Romance scams. Scammers may exploit emotional vulnerabilities by developing online relationships with seniors and then requesting money for various reasons, such as travel expenses or medical emergencies. Imposter scams. Fraudsters may pose a government official, utility worker, or tech support personnel, claiming that immediate payment is needed to resolve a problem or avoid legal issues. Home repair scams. Some scammers may offer home repairs at an inflated price or substandard work, taking advantage of seniors who may be less mobile or knowledgeable about home maintenance costs. Financial exploitation by caregivers or family members. And I hate to say this, but this is the one I see the most. Unfortunately, individuals in trusted positions may take advantage of seniors by misappropriating funds or coercing them into financial decisions that benefit the caregiver rather than the senior. Risk factors for financial fraud. Cognitive decline. Seniors experiencing cognitive decline may have difficulties recognizing scams or managing their finances effectively, making them more susceptible to fraud. Social isolation. Seniors who are isolated or lonely may be more likely to engage with strangers, including scammers, as they seek compassion or conversation. Lack of awareness. Many seniors may not be aware of the latest scams or fraud tactics, leaving them vulnerable to exploitation. Trusting nature. Many seniors grew up in a time when trust was more prevalent, making them less cautious and more likely to believe in the legitimacy of unsolicited offers. Financial vulnerability. Seniors on fixed incomes or with limited financial resources may be more desperate for quick cash, making them targets for fraudulent schemes. Strategies to prevent financial frauds, education and awareness, inform seniors about common frauds and scam tactics. Regularly share information about new scams throughout the community newsletters, workshops, or family discussions. Encourage skepticism, teaching seniors to be skeptical of unsolicited offers, whether by phone, email, or in person, encourages them to verify the legitimacy of any request before taking action. Establish trusted contacts. Encourage seniors to share their financial information and concerns with trusted family members and friends. Using open communication can help identify potential issues early. Here's the big one. Monitor financial accounts. Help seniors set up online banking alerts to monitor their accounts for unusual transactions. Regularly reviewing bank statements together can help spot any discrepancies. Limit personal investment information sharing. Advise seniors to avoid sharing personal information such as social security numbers, bank details, or passwords over the phone or online unless they are certain of the recipient's identity. Secure financial documents. Encourage seniors to keep important financial documents in a safe place or to shred any documents that contain sensitive information before disposing of them. Report suspicious activity. Inform seniors about how to report suspicious activity or potential fraud to local authorities. The Federal Trade Commission or local adult protective services agencies. Involve financial advisors. Encourage seniors to work with reputable financial advisors who can help them manage their finances and identify potential red flags. Don't hesitate to seek professional help. Financial advisors with experience in elder care can provide valuable insights. Similarly, Legal professionals can assist in drafting necessary documents like wills and powers of attorney, ensuring everything is legally sound. Support groups encourage seniors to join support groups or community organizations focusing on elder safety and fraud prevention. These groups can provide valuable information and foster a sense of community. Financial fraud against seniors is a serious issue that requires awareness, education, and proactive measures to mitigate risk. By fostering open communication, educating seniors about potential scams, and encouraging vigilance, family and caregivers can help protect vulnerable individuals from financial exploitation. And empowering seniors with knowledge and resources is key to enhancing their financial security and well-being. Let's explore some tools and resources that can aid in financial planning. I've included in your packets, those are the white folders, a few different things for you, a budget worksheet and a financial planning questionnaire that I use. There's also a bunch of apps online that you can use as well. The important one I want to go over with you though is the financial care plan worksheet, which I've also included in your packet. Creating a financial care plan for aging seniors is critical for ensuring that financial security and well-being. A well-structured financial care plan helps senior manage their finances effectively, preparing for future needs and ensuring that their wishes are respected. Did everybody find it? It's like 3 pages. It says financial care plan worksheet on the top, well, underneath the logo. Yeah. What's that remote? All right, number one on that list is the personal information. And not only your name, date of birth, social security number, contact information of your important person, but a list of your doctors and a list of your medications. Now, my mother, a couple weeks ago, gave me a list of her medications that didn't fit in these lines. So I told my assistant, whose name is also Michelle, I'm like, Michelle, I think we need a couple more lines on there. But that's important because if you go into the hospital, I don't know what you're on. I don't know if they're going to try to give you something that's going to, react with all of these medications that you're on. And I need a list of your doctors. I don't know out of the 10 doctors you go to, which ones you go to most to. I don't know these things. So it's important to have that somewhere that you can access it if there's an emergency. Financial overview is number 2. Income sources. Where's the Social Security going and what bank account? Where's the pension going? Retirement accounts. Where's the 401ks, IRAs? Any other type of income that's coming in. It could be rental or what have you. What are the monthly expenses? If you're in the hospital and I have to step in and pay your bills, how do I know what I'm paying? Are they set up automatically? Do they come in the mail? You got to tell me these things. Number 3, budgeting and expense management. Creating a monthly budget is very important. We need to list all the income and expenses, identifying discretionary spending, looking for areas that we may need to cut back if something happens, set savings goals for emergency or unplanned expenses, or maybe you want to go on a vacation. Number 4, estate planning. Will, trust, where's the power of attorney, where's the health care? I will say, even for myself, and my husband knows that my son knows this, who actually still lives with me because he's in college. I have a binder that sits in my bookcase. It has my will, it has my trust, it has my healthcare power, it has all my accounts in it. And they know if something happens to me, you pull the binder. It's all there. Insurance reviews. Where's the health insurance card? Are you on Medicare coverage? Supplemental insurance plans? Do you have long-term care? Where's your life insurance? We need to maybe look at that. How old is it? Is it 5 years old, 10 years old, 20 years old? Same with your will or trust. When was the last time it was looked at or updated? Long-term care planning. We need to discuss, do you want to be at home? Do you want to be assisted living? I'm sure nobody's going to say in this room, I want to be in a nursing home, right? Or maybe you do. Some people like it there, I'm sure. But as far as, yes, as far as my mom is concerned, she does not want to leave that house. So in that case, who is going to cut the grass? Who's going to take care of the house? Who is going to be home if you need assistance? I need to know what you want so I can fulfill those wishes for you later. Funding for care. What investments are we using? If we don't have long-term care insurance, do I have to turn on income from your IRA account to cover these expenses that you're going to need at home? Your financial advisor needs to know that too. We have a financial plan in place. We know exactly if this happens, what I need to do to get you the money that you need. The fraud prevention is number 7. It is very, very important that you monitor these accounts. And I am very lucky because I have 3 brothers. So not only I look at things, but my other brother, who is also an attorney, looks at it as well. My other brother is very good about staying around the house a little bit more with my mom and making sure things are fixed or safe or whatever needs to happen. And she's not stepping on a ladder to change a light bulb when she doesn't need to. So maybe if you have one child, great. If you have more than one child, that's even better. If you don't have children, who is your good friend? Who is your attorney? A lot of my clients visit my office when they're older with either their spouse or one of their children, or I've even had friends that step in because maybe they don't trust their children, which is, kind of common sometimes. So who is your best friend that you trust that if something happened to you, that they could step in and take care of things? Because the financial fraud has gotten so out of hand that I see it so much more than I saw it 10 or 20 years ago. So that's an important thing. And now I almost fell for a text message the other day from my bank. And I'm like, wait a minute, that can't be right. They don't, that's not it. So I was like, oh, I'm glad I didn't click on it. But it's almost that easy, especially if you're running around and you're not really paying attention to that text message that just popped up. So that I would say is a very important new aspect of things that has gotten a little bit more uncommon. Number 8 is communication plan. Regular check-ins are important. I always say when you do a plan, it's not a one thing, it's not a set and you're done. You got to relook at it every year or when something happens to you. Did you get sick? Did you fall down the stairs? Did you have to move? We have to look at this plan every time something significant happens. Which brings me to number 9, which is review and update the plan annually is good. And writing down, obviously, what circumstances are happening, or maybe we need to create a new something for the future that we didn't anticipate last year. Okay, gathering the necessary documents, collecting all important documents, including financial statements, wills, trusts, insurance policies, medical records. Remember how I said I have that binder that sits on my thing? Everything should be in there. So if somebody needs to grab it, they can. Also engage professionals, considering obviously financial planners or attorneys that can ensure that the healthcare plan is complete and legally sound. Obviously, we're going to involve the senior in the discussion to ensure that their wishes and preferences are reflected in the plan. This promotes a sense of control and respect for their autonomy. Educate and support, providing ongoing education about financial matters, including budgeting, fraud protection, and understanding benefits. By following this worksheet and these steps, families can create a robust financial care plan that adjusts or addresses the unique needs of aging seniors, ensuring their financial stability and, the most important part, the peace of mind as they navigate this stage of their life. In conclusion, see, I told you I couldn't talk longer than a half hour. In conclusion, effective financial planning is critical for seniors facing dementia. By starting early, involving caregivers and utilizing available resources, families can navigate these challenges with greater confidence and security. I encourage all of you to take action by initiating these conversations about finance with your loved ones. Encourage that they all have necessary support and documentation in place to protect their interests. Now, I'd like to open the floor to any questions that anyone has, or if they have an experience that they'd like to share.
Because I went through this with my mom. She will not let us do any of this.
I know.
I mean, she has been killed. Like, for instance, she has a safe with all her papers in. You have a combination where we take a sledgehammer and then she dies, and that's how we can get in.
Is your mom still at home?
Well, she just had an issue and was in rehab, and now she's back home. So I lined up all this care to the Michigan through the agencies that lady come in so she could shower, some of the housework. My mother wants my sister who lives across the road to check on her like 3 times a day, although she works at
Yeah.
miles away.
Oh, geez.
And so the mail lady, I don't know, there's a form she signed, the mail lady comes to her house, actually knocks on the door, goes in and hands her her mail. Which that's.
I don't feel comfortable with that.
Oh, it's the same mail lady she said.
Yeah.
Well,
Maybe
that's
I'm
what-
shady because of what I've seen though.
That's one set of eyes. I said, get Meals on Wheels. I know what time they come around, that's 2 hours before the mail, there's another set of eyes. Oh, I couldn't eat that, that's just slop. I said, I don't care if you eat it, feed it to the dog, there's just another set of eyes on you that, and if you need to be checked on more than twice a day, you don't need to live there. She lives out in the country, on farms, there's no internet, there's no cell phone. And that was her choice, so we tried to make it that she could come home. So we put all this stuff in place and she flat out, because she doesn't trust anybody to come into her.
Raising parents are difficult. My mom is very, very stubborn. I have tried multiple ways. Luckily I manage her finances already, so that's not really the biggest issue. But having somebody come into the house is my mom's biggest issue. My brother has threatened her, so, and that hasn't worked. However, it started to make her think about things. I think he said to her, it was a couple months back, if you fall down the steps, because I always say, keep your cell phone on you, mom. And she doesn't like to do that. If you fall down the steps and you break something, you will be lying there for at least 2 days before somebody figures out you're there.
So she puts her own self in the nursing home, we didn't even have to
do it. And I think when that was said to her by my brother, it got her thinking, okay? So she started really thinking about these other things. And I don't want y'all to go home and threaten your parents. Because we don't want to make them totally close off, but at some point, something is going to happen, which is going to twist her arm to make her do it. So maybe something can be said like, look, I understand how you are feeling. A lot of people feel this way. However, if we don't have something in place, if something happens to you, I'm going to have to put it all in place. And whatever you feel or you want is not going to be relevant at that point.
Well, I stayed with her for 4 days, 500-mile trip, and I was there with the nurses and all their therapists came. So we had to do a tour of the house. She's a hoarder. So we went through all these rooms, and this occupational therapist said in the state of Michigan, as long as she's of sound mind, she said, you couldn't believe the pig pens I go in. You can do nothing about it because that's their choice.
Yeah.
So she has all these knickknacks and she told my mom, if you fall, this is all glass, you're gonna cut yourself. I'll be darned if the girls will cut your toe on a porcelain doll, the caregiver.
Yeah.
After you. And so you're kind of tied. You can't really do anything. I can't force her to do anything.
You cannot. You could try to get through to her. It's recording and.
All right, good afternoon, everyone. My name is Jennifer Ramon. I do have some paperwork on the table there, my pens as well. So I was with a firm called Onspach Law. Last year they closed and I went solo. So the phone number on the pen is the exact same, same area of law, just a different firm. Now I have my own firm. So today I want to talk about basic estate planning, just so I give you a understanding of the process. But then we're going to focus on the financial changing of the guard, which is when a time where, adult children are now trying to take care of their parents and all the different challenges that you will experience for that, as we actually alluded to some of those today. So again, we're going to focus on, oops, yeah, there we go. All right, the fundamentals of estate planning, the importance of preparing for financial transitions, the changing of the guard concept, and the common misconceptions about power of attorney or POA, and I will refer to it a lot as POA, it means power of attorney enforcement. So is Dorothy here, wills, power of attorneys, living wills, oh my, and overwhelming. But this is what I don't want you to do, which is stick your head in the sand. Because you know why? This is why. If you don't create your plan, the state of Ohio has one for you. It's laid out in the statutes. And it's going to be a bigger drain on your estate financially if you don't properly plan. So for instance, if you have to go to probate court, okay, you're going to have attorney's fees. You're going to have executor or administrator's fees. You could have appraiser's fees, filing fees. Creditors can now attach to your assets. It could be bond premiums. So again, it's that slow drain on the estate that you could be leaving to your family. If you are still living, but you don't have financial power of attorney forms in place, then the same process happens through a guardianship. Again, there's going to be all of these different fees and monies that essentially go out the window because you didn't have the power of attorney forms in place. And by the way, if you have questions while I'm going through, please go ahead and raise your hand. We can address it at the time we're talking about it. If you want to wait till the end, that's also fine as well. So I'm going to go through the basic estate planning documents, which of course is the last will and testament. We have the statutory or financial power of attorneys, the healthcare power of attorney, a living will, and some other avenues that we can do for transfer, the transfer on death affidavit and pay on death beneficiary designation. I am going to go through all these briefly to explain. So the last will and testament is the document that tells the court who you want to be in charge of your estate, which would be known as your executor. It's going to have a provision in there that you don't want them to post a bond, which means they don't have to go to an insurance company and get bonded. That's money out of their own pocket that they would have to pay just to put your estate through probate court. If you have minor children, this is the document that says, who do you want to have custody of your children when you pass away? But it's also a place for you to detail who gets what. And so, the common scheme is right to my spouse, to my children equally. But if you want beyond that, you're definitely going to want a will. Because there's situations like if you're just living with your significant other, you've been married before, now you're just living together with someone else, they will not be provided for unless you say they get some. So you have to keep that in mind that there's no entitlement there to any of your assets. So again, those important decisions, who's going to be your executor? An executor is responsible for gathering all the assets, going to the banks, getting the statements, working with the attorney to get those documents through court. It's legwork. It's a lot of legwork that they're gonna have to be doing, filing your tax returns, things like that. So you wanna pick somebody who is responsible and responsive. If you choose somebody who really isn't good with paperwork and details, this is gonna be a more expensive procedure in court. Example, today, I had an executor, we had a court hearing scheduled. 15 minutes before I get a text message, I'm not gonna show up. Okay, that's great. Guess what? Everything just got continued. Now there's more expenses to the probate matter. And again, the guardian designation for minor children. Probably most of us here don't have minor children, so I won't focus on that too much. But if you have questions, let me know.
I have a question on the
Yes.
guardian though.
Absolutely
You not still have guardianship of a person who has dementia.
correct.
Is there any advantage to that over a POA?
So the courts do not want guardianships, right? That's very, very intense. It's invasive, right? They want everyone to have the power of attorney forms. But sometimes the situation arises where we have to go the guardianship route. It's a lot more, it's court oversight, there's reporting, sometimes there's bonds. So
What's the
advantage,
advantage to it? Is there any advantage with them?
it's just sometimes you have to do it because there's no financial power of attorney forms in place.
Oh,
So you don't usually want to choose that route. It's your last resort route.
There also are guardians of the person and guardians of the estate.
Correct. They can
So-
be separate,
Yes.
could
So
be
it's a
only
difference.
over one,
Mhm.
could be over both.
Is it safe to say that the guardianship thing would come into play when, say, it becomes an issue and the individual is no longer able to appoint someone their power of attorney? So they're at a cognitive state that they can no longer do that, so then you have to go the.
Yep, absolutely.
guardianship route.
Not get their power of attorney forms done. And now they don't have capacity to execute those forms. Guardianship is the route that you would have to take.
Is this different in different states? I was in Iowa when my parents were encouraged by my brother to get power of attorney. I was told in Arizona and Iowa both, that the power of attorney was for temporary things, like I am gonna be a year in Europe or something, somebody needs to pay a bill. But it wasn't designed for that. The problem with the power of attorney, I was told, was that when the person needs it most, then it's rescindable. Is it not rescindable? When somebody has a.
Oh, yes, yeah.
We all exact, and they said it too many times. You know, when they need it most, well, just like the lady that was, having problems with her remote, wouldn't sign it once you get all ready to sign it, right? And and we get like that more as we go.
Yeah, absolutely. So
It's rescindable here too.
let me start. It is different in every state. Every state has different types of power of attorney forms. In Ohio, we have what's called the durable power of attorney form, which means it's effective while you're capable, right? And when you lose your competency. So for instance, you are getting ready to close on your house, but you have to have emergency surgery. You can send your power of attorney agent with your form to sign that, right? You're mentally fine. You just physically can't be there, right? So your agent can do that for you. When you become incapacitated, yes, the document technically is not revocable at that point, but it can get revoked. So there's the typical lawyer answer of it depends. On the circumstance, yes, go ahead.
Okay, with one firm that I was dealing with my husband, I heard is the power of attorney, they said, we don't accept that. Do they have that option?
Yes,
Okay.
yes, and that is,
then I had to go through another set of rigmaroles.
yes, and I definitely will be going through all the
Okay.
issues of how that works.
Some banks do it too.
Absolutely. Absolutely, it is very frustrating, and I have slides to go over all those.
Really,
Yes. But the purpose of what a financial power of attorney is supposed to do, right, is to give an agent that authority to act on your behalf for certain financial transactions. Now, these transactions are spelled out in the statute of Ohio. You can't, create a trust for someone or change their beneficiary designation. It does not give that authority. But it's basically, I can file a tax return for you, you can't sign anymore. I'd like to say you should be able to write checks at a bank. But there's more steps involved, right? It's not just to automatically take the form in with banks. They do what they want. I call them the wild, wild west. Because each of them is also different. But the purpose of this form, again, is to allow somebody to access some financial transactions and things on your behalf. That's the purpose of it. A healthcare power of attorney, again, same concept, except a little bit different. Here, you have to not be able to speak for yourself. Or the financial power of attorney, that does not apply. So here, if you're in the middle of a procedure, they can't just say, hey, you want option A or B. They have to call your power of attorney agent to make that decision. So those are the difference between the two. And guardianship designation, you actually can also make this in your financial power of attorney form and your healthcare power of attorney forms. I don't believe the standard ones allow for the guardianship, or they might just have a little section in there. But there are more expansive ones where if you are incapacitated, it tells the court, at least you want these people named as a guardian, right? It gives the court options to choose from. So that way you don't have maybe an irresponsible son that you would never want to be your agent applying to the court, because now you have a document that says, I didn't want him, right? That's a bad choice. So that's a good option to put into your financial and healthcare power of attorney in case a guardianship arises.
Do you recommend a separate health and separate financial?
They need to-
attorney,
they need to
or
be
all in
separate.
one?
They need to be separate.
A separate person, you mean? Person.
They're separate documents, separate document. And you want to choose the people that are best suited for the position, right? You don't want to appoint your child who loves to go gambling all the time and has no money in charge of your money, right? You have to think about who's the best person. It doesn't matter if they're your oldest, right? A lot of people have that misconception. Well, they're my oldest, that's who I have to appoint. Or they're closest to me, that's who I have to appoint. You want to choose the person that's best suited for that role. So if you have a child that's a nurse, great. That's a great candidate to be your healthcare power of attorney agent, right? You understand a lot of those things. Your living will. This is the document that indicates if two doctors have come in, determine you're permanently unconscious, it tells them that they can take you off that life sustaining equipment. Otherwise, they will keep you on that equipment for a period of time. The family, of course, may then start to say,
Even if my healthcare power person says, we don't want him on that equipment. You know what I mean? The
so.
doctors put you on,
Mhm.
and my healthcare power of attorney says, we don't want her on there, she doesn't want that.
So
The
your
doctors won't.
your healthcare power of attorney is going to say that your agent has the discretion to keep you on or take you off.
Yes.
It becomes their decision.
Okay, not the doctors. You know what I mean? The doctors.
Right. Your healthcare power of attorney sets that forth. Your living will is your desire not to be kept on life sustaining equipment. So those documents work together. If your agent that's in your healthcare agent can't make the decision, they don't really know if that's what you wanted. The living will then comes out to tell them, oh, they don't want to be kept on that equipment. So the documents work together. I always advise, I don't really hand out the living will to my doctors freely. If I put the provision in my healthcare power of attorney that my agent can make the decision, because I want them to make sure they're talking to my agent first. And then if something happens, we can get this out and give it to the hospital. So just a little tidbit, I love this part of Ohio's law where you can add a beneficiary to your house. So instead of having to go through probate court, you can have what's called a transfer of death affidavit, record it with the recorder's office. When you pass away, whoever that beneficiary is going to go to an attorney, get an affidavit of survivorship, attach the death certificate and record it, and the house is theirs. They don't have to go through probate, they save a ton of money with that. So this is a great piece of information, yes.
So if you have a trust, do you need this?
If you put your house in the trust, no, you would not need that.
Oh,
Yeah, this is an alternative way to keep it out of probate without having a trust.
So for a husband and wife, if my husband were to die, that this should be in place so the house just goes directly to me.
If your
Fine,
deed
it's
has
7%.
survivorship language on it,
Okay.
that will be automatic.
Okay.
But if something happened to both of you at the same time, you don't have a beneficiary.
Okay.
Yes,
Is that like a different deed?
it's an affidavit that gets recorded, so it basically attaches to your current deed.
Okay, I had a survivorship deed, my husband passed away. And, okay, I did another deed. So.
So you did a deed to get it out of his name into your name solely.
No, I did a deed that gave my beneficiaries up.
Okay, it's not actually a deed, if you look at it, it's an
I
affidavit.
thought it was. Okay,
I mean,
it was a deed.
It functions
It's
that
called
way,
a
but it's not a,
transfer and death
it's,
affidavit as opposed to a transfer. of
yeah, 'cause
death
it's not
deed.
transferring now, right? Deed is a direct transfer now. An affidavit is something you want to happen in the future, or a confirmation of something that has. Same effect though, as long as, you know, you don't change it, you can change it at any time. Did you have a question?
I just want to say that that TOD is great if you're alive and you pass away and you're fully I mean, fully and got yourself together and everything, but if you are like going downhill fast and you have a big estate, let's say, wouldn't you have to like quit claim deed your house so that like 5 years before it get bad? So they can't take your house away?
Those are two different concepts.
Okay,
So what you're referring to is a Medicaid look back period,
right,
which is 5 years before you would apply for Medicaid. This
Okay.
has nothing to do with that, because this is a transfer that will happen in the future.
right, right.
So that does not affect that. A quit claim that you're talking about, if you're quit claiming it, which that's a whole nother topic to discuss. If you're quit claiming it to someone else as a gift,
Mhm.
then you better not need Medicaid for those 5 years after that transfer.
Right.
Or if you're gonna do penalized.
Right, right,
Yeah, but
That's why I wanted to
this is
clarify.
completely outside of that.
right.
Now, if you end up going on Medicaid and after you pass away, they will put a lien on the house. So even if there is transfer on death, it's gonna be transferred subject to
Right.
that lien. And the family members will have to clear up that lien on the house.
Right.
So keep that in mind.
Yep.
Another great way to avoid probate court is to make sure you have pay on death beneficiary designations for all your other property. You can do this for your bank accounts, your vehicles, life insurance, retirement plans, investment accounts, CDs, and savings bonds. So in Ohio, we're very fortunate that we have the ability to do beneficiary designations. And again, this will keep it completely out of probate court. And then, of course, there's the advanced estate planning documents, which includes trusts. Now, most of what I discussed is just to keep out of probate without going the trust route. You can also go the trust route. You have more control over your assets that way, and how things are divided, distributed. But again, a trust isn't for everyone. It's really circumstantial. So it's based on your circumstances, yes.
Before we go to that, can I ask one question?
Sure.
If we do that, POD, TOD affidavit,
Yes.
okay, and you can do all those things to get beneficiaries. What about your personal belongings? Because you don't have those designated for anywhere that I know of you can do.
So if the only items you have are non-titled personal items, if your family agrees who gets what, you don't have to bother the court. When there's conflict, you'll have to admit the will and the executor will have to get everything approved. So probate, if you have titled assets that need to get transferred otherwise, because they didn't have beneficiaries, then you can include your personal property, but typically you don't put just personal property through.
Does a normal will, when they have it already filled out, I mean, formed, does it say like your possessions in there?
So most
think it
wills are
depends.
generic as far as I want my tangible personal property to be divided amongst my children.
Okay.
And we attach to the back, at least I do in my wills, a property memorandum. So if you know you have specific items that go to specific people, that's where you can put them. And if you change your mind, you just cross it out, date and initial it, and it's been revoked. You don't have to redo your whole will.
Thank you for.
Yeah, so
Well, speaking to what she was talking about, because it says, like our house, we divided 6 ways. But it doesn't mention the content, so it seems to me to experience with my friends, that's where all the fighting comes in.
I mean, it absolutely does.
Because the contents aren't addressed, so they're in there fighting over the Tupperware.
No, it is 100% true. That is 100% true.
We just decide that we're not going to fight.
Well, okay, so a very good friend of my mom, her mom died yesterday. She has 7 kids and 24 grandchildren. She made a list of all the things that she wanted to go to certain people. Made sure all the kids had it, and it was just it's being disposed of that way. That way there was no fighting, there was no anything. Now, this is not normal, because there will be fighting at some point.
Those will be hard feelings. because-
Most of-
Absolutely.
And you get that.
Absolutely.
But this is really, I think this is really going to stop a lot of it, because she moved into her own house, so a lot of that stuff has already been distributed like a month ago, right? So maybe something like that, if you can trust your people enough
Mhm.
to do it.
And, I would say, if you can transfer stuff like that, personal possessions, while you're still living,
Do
you
it.
really need that old china anymore? Pass it on, right?
You're not wearing that diamond ring.
You're,
give it away.
you're avoiding some of that conflict, but communication is key. But again, there's still gonna be hard feelings, even though everyone knows that Betty should get this,
Yeah,
there's still gonna be hard feelings, and
yeah,
unfortunately, there's no magic wand to make that go away.
and that's not a legal issue, that's people.
That's a family issue,
Yeah.
absolutely.
Back to your, DOD.
Yes.
The flowers.
Saving your account, to go with some of the sense of God, give some money in there, who gives next some money together, so say husband, wife, no problem. So you put your kids
My
out,
sister thinks.
is there a form that you have to fill out to get the kids that form so they know what's in there and who it goes to?
So I would
Who's
suggest,
responsible for that.
yeah, like nobody's really responsible for that except for you. So if you go to the bank and you add your children as beneficiaries, right? You just need to tell them in your, like, give them copies of stuff. Here's where I bank, your beneficiaries. Everyone has to go to the bank individually and they get the portion of what they would get from the account. So there's not like an executor that's in charge of that, not with beneficiary designations. Each individual person is contacting these agencies.
Because of the fact that you put their name on there when they come in there with their driver's license.
Yeah, one of them will have to have the death certificate to get the process started, but then, yeah, they all have to go in themselves,
show
their driver's license,
So just as easy.
much easier than probate, absolutely.
So you can put a beneficiary on a
And
bank
then we
account
can.
Yes.
instead of just putting,
Yeah, I recommend
adding
that,
them to your
yeah,
account.
so there's 3 ways to deal with bank accounts. The joint owner, hate that idea, because now that money is also there, even though it's only yours that you're putting in, they have entitlement to that money. They get sued and their wages or their bank gets garned. Guess what? That money is subject to that. So putting a joint owner is very, very risky. You can put them on as a power of attorney agent. Again, has to be done at the bank. They typically have their own forms. And that's usually what I tell people. When you get your power of attorney forms done, take it to the bank right now when you're in good health and you don't need it, so that you can find out what their requirements are, because they probably have their own. And the other one again is adding the beneficiary. Yes, that means they don't have entitlement until you get some. You can change that at any time you want, but you have to go into the bank. Typically now they require appointments. A lot of times you need the social security numbers. All right, so we're gonna talk about get my.
I'm trying to set up everything so that we don't have probate. But in my will, just in case. I put all three of my kids as executives.
As like joint, like they all have to act together.
Yeah, which I know is really rough, but I feel.
Yeah, that's a nightmare for the lawyer. You're absolutely
It's a
right.
nightmare for the financial advisor.
Because I'm hoping you don't have to do anything,
Mhm.
It is what
you
it
know,
is.
at all,
Yeah.
but, okay, if you had, like, I have a really old car. And I only have it in my name, but I do realize in Ohio, you can put a beneficiary on it.
Mhm.
If they only have that one thing to probate. Because I mean, I die before the car does. They can do that without a bunch of difficulty.
So there's I don't wanna call it a small estate, but essentially it is. If an asset's under 35,000, it can get through probate fairly quickly, in about 90 days.
Okay, and everything.
Maybe less if everyone cooperates and signs.
I just didn't want to choose.
Understand,
kids.
understand.
And
Offer? What kind of,
Now, here,
you got there, what?
kind of car is it? You know, for an offer?
2008.
Okay.
Say,
Well, wait, here's where communication comes in. Did you ask one of them? One of them might have been like, I'll do
I'll
it.
do it, and the other ones don't
You
care.
don't wanna do it. I don't wanna do it.
Okay, that's a good idea.
Talk, have
Yeah,
the communication.
Absolutely.
Another thing I found is if you want to give bank accounts or whatever to charity. There are some institutions that will not let you put charity, a charitable organization.
Wild Wild West,
Why is it?
their own policies.
You're right, that's
Yeah,
what they
They
say.
can do whatever they want. For instance, I had one credit union, so it's a revocable trust. If you put your house in a revocable trust, you can do anything you want with that property, right? You can transfer it, whatever, mortgage it. Well, this particular institution said, no, even though it's a revocable trust, we want you to pull it out. Then we'll give you the home equity loan, then you can put it back in. It's like, seriously? Another financial institution's like, no, there's no need to do that. So they can do whatever they want. And nothing we can do about it.
So my question is about executors. So
Okay.
does, in Ohio, does an executor have to live in state?
All right, so yes, but no. Again, it depends. All right, so with what's called the smaller estate that I was discussing, yes, if they do not live in the state, the court won't recognize them. But they're not really an executor, they'll be called a commissioner. In those circumstances, me as the attorney, I just become the commissioner and get it through the court quickly. With a full administration. Some courts will allow it. Wood County had no problem having a Boston executor. Lucas County, I have to co-sign everything. So, or the person has to post a bond, even though the will says no bond. So just like banks, courts can also do whatever they want.
Being it mattered on the value,
Yes, the bond would be based on the value,
you said small estate
under 35,000,
is what they don't recognize
correct.
or estate.
Mhm,
And that only means the probatable part.
correct. Yeah, anything that passes by a beneficiary is not included in your estate. Another benefit of adding beneficiaries to your properties is your debt collectors can only collect from your estate. If you don't have anything in your estate, because as soon as you die, by operation of law, it's now your beneficiary's property. Nothing to collect. Nobody's required to pay your debts. So that's also another way to.
Run it by the homeowner.
Absolutely. So
Run
let's say you have,
that by me again.
yeah, doing it right now. Let's say you have hospital bills, $10,000 from when you passed away. If all of your property passed by beneficiary designations, you don't have anything that's going to probate court. That $10,000 debt can only collect from the estate that goes to probate court. So if that's zero, there's nothing to pay those medical bills. Wow. That's only Ohio. Other states have different laws.
Does that include credit cards and other stuff?
And if, let's say you do have property that has to go through probate court, if you can hold on for 6 months before opening a probate matter, The statutory time to file that claim has expired, and now they still cannot access your estate. So, Very, very good information. All right, so let's go back to the challenge of enforcing power of attorney forms. As we discussed, resistance from the aging parent, right? They don't want to give up that control, and there isn't a lot you can do about that if they have their capacity, because they still have the right to do whatever they want, even if it's unfortunately what we think is bad for them. Now, if it gets downright harmful, that's when you start calling the authorities in, right? And there's different agencies that can assist with that. But if not, unfortunately, that's just something you have to deal with. Third-party hesitation, which again, the banks or other agencies that may say, oh, no, we're not going to take that. And guess what? They can get away with that. And then again, family disputes over the authority. So we're going to dive into these a little bit deeper. So legal hurdles in enforcing a power of attorney, right? Banks refusing to honor POAs. That is why I say when you get a power of attorney financial one done, go to your bank right away. See if they're going to recognize it. See if they have their own form that they would prefer in place. Get it done right away when you don't need it. Again, state-specific requirements. So for instance, in Ohio, you have to have it notarized. There are other states or 2 witnesses, right? Other states, they might have different requirements. So wherever state you're in, you want to make sure you're executing it properly, or when you need it, it's not going to be recognized. And again, we got those family disputes. So we're going to talk about making sure you're using the right document. Yeah, absolutely.
So just to clarify, when someone does not have a financial power of attorney, like let's just use my mother-in-law, for example, and she either got sick and incapacitated or passed away, without that financial power of attorney, none of her children have the authority to pay any of her bills, do anything, sell her house. All that would then have to go through probate.
Guardianship.
Guardianship if she's still alive, probate if she's
Correct.
I was just having this conversation with her the other day, and I'm like, you need to do that.
Yes. So again, you want to make sure you're using the right document, but not just even the right document, an up-to-date document. I've had clients come into my office and they still have their power of attorney forms from the 90s. Great. I can guarantee you nobody's going to accept this form. So I always recommend every 5 to 7 years getting those updated because you want them to be fresh. Because you don't want that to be the reason that the agency says I won't take it because it's too old. That's just going to delay what you're trying to do. Also, contact information are on these forms, right? So especially with let's say the medical one, if they need to call your kid, but they have a new number, they're not going to get hold of them, right? So refreshing these documents also updates contact information for the people that need to be contacted. Again, I discussed going to the financial institution, talk to them ahead of time, make sure that they can get that in place for you. Communicate with family. A lot of times, I'd say most times, people go home, put their stuff in the safe, their kids don't even know they have the forms. You have to communicate what your wishes and desires are, because that is going to help alleviate some of that conflict. I mean, it's not going to cure it, but communication will help to alleviate some of it. And a backup plan, at least for the financial part of it, you could put everything into the trust, and the trustee then has more authority to handle that property. So for instance, with the revocable trust, you are the grantor when you create the trust. You're the grantor. You've given property to this trust. Typically, when it's a revocable trust and you're in good capacity, you're also the trustee, which means you can do whatever you want with all the property. If you become incapacitated and you don't have a power of attorney form in place, your successor trustee can just get a doctor verification saying there's capacity issues. They now can step in and be the trustee and manage the affairs. Okay, so it's another way to help if you don't have a power of attorney form, but you do have a trust in place. Again, sometimes a power of attorney form is not enough. You can do all the best efforts, but that financial institution still will not acknowledge it, right? You might have to go to the guardianship route. And again, you can only get there with incapacity issues, right? The court does not want to grant guardianships, right? They want to do the least invasive paths first. And this is like a last resort. Guardianships are lengthy. They are extensive. There's court oversight. There's court reports that have to be done annually. Power of attorney forms are the less invasive way to do this. Now, of course, power of attorney forms are limited when you have cases of refusal. Again, as I mentioned, you can't force people to do something. The only way you get around that is if something that's going to be very harmful to them, immediate harm, and then you get other agencies involved. That's not happen very often. It's very difficult to enforce. All right, so as I kind of alluded to some of these before, you know, a client goes to the bank when they need the power of attorney. We have to write mom's bills out now. Well, the bank never looked at that power of attorney form. They have their own requirement. They don't have to acknowledge it. And so you better hope mom still has capacity to execute another power of attorney form or go into the bank at some point and do that. So that could delay, you know, something that you need now. Family disputes, again, over the power of attorney authority. Communication is key. I can keep saying that, but if you can't force your parents to also talk about these things either, right? So sometimes, I mean, you're either going to involve lawyers, and that's going to get expensive, or maybe you could try a mediation approach. But again, you're dealing with people and emotions and highly charged issues. It is difficult to navigate. So again, plan ahead, don't wait for a crisis. Proactively engage with your financial institutions in advance. Communicate with your family to prevent disputes. Update your power of attorney forms regularly, 5 to 7 years. And again, know that last resort is guardianship. No privilege offered. So again, if you get these things in place, hopefully you don't need to go to guardianship. All right, great.
So just, I'm not asking for an exact amount, but just kind of a general idea, how much would it cost someone to come and sit down with you and create all these documents, or have all this in place?
Absolutely. So I do package pricing as much as I can. So for a basic, what I call a basic will package, for an individual, that includes a will, financial power of attorney, healthcare, living will, and I also throw in a HIPAA authorization. For individual, it's $400. If it's a couple, married couple, $700. To do the TOD or the transfer on death, I charge $100 for the deed. Recording costs are somewhere around $50. If you want to go the trust route, go ahead.
What was that again? The transfer upon death?
Transfer on death, I charge $100 to do the deed.
Okay.
Or the affidavit, and $50 for the recording. It's usually around 50. Whatever the recorder's office charges is what I just try to give an average. You know, trust will start at $1,200 on up, depending upon if you're doing other forms with it or what type of trust that it is. Any other questions? So this part I really love to go about, because these are real life scenarios when people either don't have wills or beneficiary designations. I really like to show the numbers. So in this scenario, this was my actually very first probate case. So this was a doozy to get started on. The decedent, he owned 2 homes. He lived in one with his girlfriend. His son lived in the other home. He had 4 vehicles, one that he had let his wife use, or I'm sorry, his girlfriend use. A travel trailer. He had 2 bank accounts. His total estate was around $287,000. He didn't have a will. He didn't have transfer on deaths. He didn't have beneficiary designations. So every asset had to go through court. He had 2 children. One of his children couldn't get bonded. So he couldn't be the executor or the administrator here. The other son was serving a life sentence in Georgia. Also not going to be a good candidate to be an administrator. So we had to get an outside person. It was a cousin. to do this, and she was not sophisticated, which is okay, I'm there to help her, but it was very overwhelming. So because she had to do that, she had to post a bond for about $2,500 out of her own pocket. She was paid as an administrator because again, she's not a beneficiary. She was doing a ton of work, so she got about 10 grand in fees. By the way, that is taxable on your income.
The beneficiary also get paid administrators fees if they're the executive.
They can, as long as the will says they can, or if it's not by will, by statute, they can for sure. As long as the will allows it, yes, but keep in mind that money is now income on their taxes. Where the inheritance wouldn't be. So you have to balance whether that's important. So how this estate got really complicated, because the son that's incarcerated, the court treats them like they're incapacitated. So we had to get a guardian appointed to review everything. The one house, that was paid off, we just transferred to both sons because the other part, he can't sign off. So we have someone who's never gonna be able to live in this house attached to the house. That's fine, but that's the only avenue we had. With the other house the girlfriend was living in, she wasn't on the mortgage, she wasn't on the deed, nothing. It took a while to get her out. We had to start proceedings for eviction, which is terrible, right? You know, he wanted to buy for her, but there was nothing there for her. Same with the vehicle, we had to take the vehicle away. Had a lien on it. Because we had to sell the house because none of the kids could afford the mortgage, we had to open a separate matter in probate court called a land sale action, so that we can get approval to sell, because again, that son has no authority to say yes, because he's in prison. So there's a separate civil action. So now we got a probate case, civil action, and an eviction going. Anyhow, crazy expensive. Filing fees were a little over $1,400. Attorney fees, a little over $17,000. So that $287,000 estate ended up with about $31,000 less than it would have, that could have gone to the heirs.
So who's it going to? Who's the remaining balance?
So half to the son that is, here in, the area, and the other half into a commissary account for the son in prison.
That's a hell of a commissary.
Yeah, he's probably really popular.
Yeah.
But if they would have had transfer of death and hand death in place, it would have cost less than $1,000 to get all the transfers.
Did you say the other house went to the guy in prison?
He's half owner with his brother who lives in the house.
Oh, I just wondered who paid taxes.
Well, you're gonna hope that the son that's living in it's gonna pay those.
Yeah,
Not if it goes to the foreclosure.
there's a story, I'll make this real quick. A single person lived out of state, had a house and property and stuff. And the parents live up here and they have had like 2 years. They're working on trying to get this sources. I mean, they have to go down to Tennessee, I think it is, and back all the time, and their courts just will not relinquish that to the parents. They're only, it's crazy. So
Yeah, it is
even
crazy.
your young, your young kids need a will.
Oh, 100%.
It's just crazy.
And power of attorney forms, because when you are 18, right? Mom and dad can't speak for you anymore. And I've had 2 situations. One where the kid went to college, was living in a dorm or an off-campus apartment. He had a nervous breakdown, had to be admitted. Partner complex wouldn't deal with parents. So like they can't get his stuff, they can't pay his rent, can't do any of that because they had no legal authority. They wouldn't let him in to get their stuff, right? I had another situation where she was 21, had a brain aneurysm. She was, in the hospital, and they would give the parents very limited information because there wasn't, HIPAA release or power of attorney forms or anything like that. And she ended up, they had to eventually take her off life support, but the parents couldn't have say in it. And so that becomes really difficult. So even at 18, these documents are important, because you don't know what's gonna happen. It's not just, you're getting old, better get it, you're living and breathing, you better have. Real life scenario number two, the decedent owned a home and a bank account with about $2,600. There was no will or beneficiary designation, on the bank account, but there was for the home. So that allowed for an easy transfer, but, we had filing fees, attorney fees. So, about $1,000 came out of that 2,600, or if they would have had a beneficiary on it, it would have cost basically 175 just doing the house transfer. So again, not having those beneficiary designations really costs a lot of money out of your estate. And last one that I have is decedent. She had 3 bank accounts, and without again, a pay on death, but she had a will. So at least this was the out of state Boston executor. They didn't require her to post a bond, which was fortunate. But it cost about $6,000 just to get that through from the account, where the POD was in place, had been 0. Yeah. So what's next? How about we get your documents in place? The County of Aging has provided some forms here. People want to take those power of attorney forms. We talked about getting those executed. Otherwise, schedule an appointment with, if you have an attorney that you work with that person. I also accept new clients, but work with somebody, get your documents in place, and communicate with your family to avoid future conflicts. Yeah, seek the help of experts, right? That's always great. Get your docs in a row.
Outwillattorney.com.
Now, I mean, I did have a client who we did their will, but they notarized it. So like,
Yeah.
so yeah,
Maybe
you
to rent
gotta be careful.